Rajasthan Tenancy Act 1955. So, in 1955, a comprehensive legislation was passed to bring uniformity in the tenancy legislation, which is known as Rajasthan Tenancy Act 1955. The act received the assent of the President on the 14th day of March 1955 and came into force with effect from the 15th October 1955. In Tehsils Abu Amir Sunil, this act was implemented with effective force on 15th June 1958. It is it as an act to consolidate and amend the law relating to tenancies of agricultural land and to provide for certain measures of land reforms and matters connected therein with. Objects and reasons. Second is omitted. Third, repel. So, first is on and from the coming into force of this act, the following shall stand repelled. So, what all will be repelled is mentioned under this section. The enactment that is mentioned in column 2 of the first schedule to extent specified in column 3, any corresponding laws other than the enactments referred to in clause A, then any laws amending the enactments or laws referred to in preceding clauses of this subsection. Then next is nothing that is contained in any act or ordinance or regulation, rule, order, resolution, notification or bylaws not repealed hereby or by the Rajasthan Revenue Laws Extension 1957 or in the terms or conditions of any order or instrument granting or recognizing the grant of a jangir or zamindari or besvedari rights, which is contrary to or inconsistent with the provisions of this act, shall be operative or in any way affect those provisions. Then any custom or usage relating to agricultural tenancies prevailing at the commencement of this act in any part of the pre-recognition state of Rajasthan except the Siroj area at commencement of the Rajasthan Revenue Laws Act Extension 1 in the Abu Ajmer or Sunil area and having the force of law shall, if such custom or uses is repugnant to or inconsistent with the provisions of this act, cease to be operative to the extent of such repugnancy or inconsistency. The provisions of any agreement relating to agricultural tenancies existing and operative at such commencement which are repugnant to or inconsistent with the provisions of this act shall, subject to such saving as are elsewhere provided in this act or in the Rajasthan Revenue Laws Extension Act 1957, become void and cease to be operative to extend such repugnancy or inconsistency. Fourth section is omitted. Section 5 is about the definition. In this section, all the definitions are mentioned of agricultural year, agriculturalist, assistant collector, bisfedar, board, sealing area is collector, then commissioner, crops, estate holder, existing Jhangir law, khatidari rights upon resumption or abolition. All of these are defined. Fragment, grant at a favorable rate of rent, then groveland, high court, holding. What is a holding? It is very important that we understand the meaning of holding. It shall mean a parcel or parcel of land held under one lease engagement or in absence of such lease engagement or grant under one tenure, and shall include in case of a izaradar or thekedar the izara or the theka area. Then izara or theka. Improvement, meaning of improvement is also defined under the section of definition, it shall mean and it should refer to the tenant's holding for dwelling house erected on the holding by the tenant for his own occupation or cattle shed or storehouse, any work which adds materially to the value of the holding, construction of bunds, tanks, wells, water channels, other work for the storage, supply, or distribution of water for agriculture purposes, construction of works for the drainage of land for its protection from floods or from erosion or from damage by water, the reclaiming, clearing, enclosing, leveling, or terracing of land, erection in the immediate vicinity of the holding, or the renewal or reconstruction of any of the foregoing works or such alterations, but shall not include such temporary wells, water channels, or buds or enclosures or other works as are made by tenants in the ordinary course of cultivation. It also defines what is a jagirdar, what is a jagir land, what is a khudkasht. Meaning of khudkasht is also defined under this. A khudkasht means land in any part of the state that is cultivated personally by an estate holder, and it will include land recorded as khudkasht, sar, hawala, nijchut, rakhate in settlement records at the commencement of this act. And what is a land, that is also defined under this definition. It also states that what is the meaning of land cultivated personally, and what is the land owner, what is the land holder. It also defines what is the landless person, Malik, member of the military, naval, or air services of India, occupied land, posture land, pay, prescribed, registered, rent. In the definitions, it also defines the meaning of revenue, what is a revenue appellate authority, what is a revenue court, what who is a revenue officer, the meaning of sayal, meaning of scheduled caste, scheduled tribe, what is the meaning of settlement, what is the meaning of state, who is a subdivisional officer. Subtenant, tehsildar, tenant, all of these definitions are defined. Like tenant means any person by whom rent is taken for a contract, express or implied, and would be payable except when the contrary intentions appear, and it will include Abu area, the permanent tenant or the protected tenant, Ajmer area, Sunil area, co-tenant, grove holder, village servant, a tenant holding from a landowner, tenant of khudkash, mortgagee of a tenancy right, subtenant, but shall not include grantee at a favorable rate of a rent, or an izredar or thekedar or a trespasser. Meaning of trespasser, village service grant, zamindar, nalbhat, all of this are defined.